Summer can be a bit of a slog. For us, it's often for some reason a rather busy time, and I'm sure we're not alone.
Well, you can beat the summertime sadness and the August angst and enhance your everyday with our excellent sponsor, Via Hemp. This is a company that crafts award-winning premium THC and THC-free gummies.
Each of these gummies is especially designed to cultivate a specific mood. Whether you're looking to get relaxed, get quality sleep, get creative, or just to get focused. If you're 21 or older, you can experience it for yourself and get 15% off your first order with our exclusive code MSheet at viahemp.com. That's VIIAHEMP.com.
I personally enjoyed their grapefruit flow state gummies. This CBG and CBD powerhouse really helped me tap into my productivity. Like, we have had an extremely busy summer, and I feel flow state got me over the finish line a few times when I was editing multiple episodes a day, digging through documents, and knocking out a bunch of interviews.
Via Hemp does not require a medical card, and it ships legally to all 50 states. It's also affordable, and even more so for Murder Sheet listeners who get a special deal.
If you're 21 and older, head to viahemp.com and use code MSheet to receive 15% off. That's VIIAHEMP.com and use code MSheet at checkout. After you purchase, they ask you where you heard about them. Please support our show and tell them we sent you. Enhance your everyday with Via.
Okay, it's time to commit. 2024 is the year for prioritizing yourself. Begin your new smile journey with Byte, and you could start seeing results in just 2 to 3 weeks. Just order your at-home impression kit today for only $14.95 at Byte.com. Byte clear liners are doctor-directed and delivered to your door. Treatment costs thousands less than braces, plus they offer financing options, accept eligible insurance, and you could pay with your HSA, FSA. Get 80% off your impression kit when you use code WONDERY at Byte.com. That's BYTE.com. Start your confidence journey today with Byte.
Have you ever covered a carpet stain with a rug? Ignored a leaky faucet? Pretended your half-painted living room is supposed to look like that? Well, you're not alone. We've all got unfinished home projects. But there's an easier way. Thumbtack is the app that makes it easier to care for your home. Pull out your phone and in just a few taps, search, chat, and book highly rated pros right in your neighborhood. Download Thumbtack and start caring for your home the easier way.
Content warning. This episode contains discussion of murder, specifically the murder of 2 children.
So, one topic of interest in the Delphi murders case recently has been that of defense crowdfunding. So, a fundraiser was set up for Richard Allen, the man accused of murdering teenagers Liberty German and Abigail Williams back in 2017. And that fundraiser had to do with getting money for trial experts to put on his defense. Now, there's a lot of complicated issues and discussions to be had around this, but in order to sort out the general topic of crowdfunding defense, we reached out to 2 excellent experts, attorneys Hilary Gerzhoy and Julienne Pasichow. So these are 2 attorneys who covered this topic in an informative article for Law 360.
And frankly, to be completely transparent and open with you, we felt it was really important to get the views of attorneys about this, more specifically attorneys who were in no way affiliated with this case. A lot of the voices we've seen comment on the fundraising has come from attorneys affiliated with the defense.
Yes. And so essentially these attorneys will be speaking on the general topic, not a lot of specific questions about Delphi because that's a bit of a unique situation, but we felt it was important to start with those building blocks.
After we hear from them, we're going to come back and talk about more of the specifics of this particular case involving Richard Allen's fundraising, maybe offer a few opinions about that. And then at the very end of the program, we're going to have a few minutes where we talk about something that's been going on with YouTube. So it's going to be a pretty busy episode, and let's get started.
My name is Anya Kane. I'm a journalist.
And I'm Kevin Greenlee. I'm an attorney.
And this is The Murder Sheet.
We're a true crime podcast focused on original reporting, interviews, and deep dives into murder cases. We're the murder sheet.
And this is the Delphi Murders. Crowdfunding. So can you both start out by just telling us a bit about yourselves, your areas of practice, sort of your background professionally?
Yeah, I'm happy to go first. So I am a legal ethics and malpractice lawyer. I'm vice chair of our firm's legal ethics group. And I also am vice chair of the DC Rules of Professional Conduct Review Committee. So that is the committee in DC that helps to amend the rules of professional conduct. And just to take a little step back, all lawyers, in addition to being subject to the law, are subject to what are called rules of professional conduct, which regulate our profession. We are a self-regulating profession. And so we all agree when we become members of various bars to adhere to the rules of professional conduct. And they govern things like how to deal with a conflict of interest, how to collect money from clients, how to, what your obligations are in terms of being honest in a tribunal, those kinds of things. And the rules of professional conduct are slightly different in every jurisdiction, but every jurisdiction has them. And so I'm the vice chair of the committee that helps to make amendments to them that ultimately get approved by the DC Court of Appeals, so that the rules are sort of constantly evolving and reflecting our practice. I also sit on the ABA ethics committee. And so the American Bar Association will set rules of professional conduct that each jurisdiction then adapts for its own jurisdiction's purposes. And then they also write opinions that analyze what the rules do. So they come up with sort of different fact patterns, either because lawyers will say, you know, how do we understand how these two rules intersect, for example, or just the committee on its own will say, I think we need to provide more clarification to members of the bar about how these rules work. And so I'm on the committee that drafts those opinions. And then I also teach, I'm an adjunct law professor at Georgetown Law School, where I teach legal ethics. And I will turn it over to Julienne.
Yeah. So I'm an associate at the firm. I work across several practice areas, one of which is legal ethics, working for partners like Hilary and others in our firm. And often what we're doing is advising clients with either more specific questions of how they do a particular thing or whether a particular thing is compliant with the rules of professional conduct in a given jurisdiction. Sometimes we deal with fact patterns where someone's suggesting a course of conduct that may be compliant with one jurisdiction's rules, but not another. Sometimes we help people set up legal practices or do specific things within legal practices. So it's quite a varied area of law that really runs the gamut from answering relatively simple questions to really helping someone establish a law practice that's compliant with rules across many jurisdictions. And as you can imagine, like Hilary was saying, because each jurisdiction has its own rule, oftentimes when you have a small law firm or a small practice that's employing people from 5, 10, 15 different jurisdictions, there are a lot of different sticky issues that come up.
So we came across the wonderful article you both co-penned for Law 360 that deals with legal crowdfunding and sort of different aspects of that. Can you let us know how you both came to be interested in that topic and sort of how that article came to be?
Yeah, absolutely. So I actually have a regular space with Law 360. I publish with them at least 6 times a year and sometimes more. And this was actually one of the editors at Law 360 sent me an email and said, I don't know if you've heard about the Neely case, but would you write something about crowdfunding legal fees because it seems like this is sort of a trend that's happening. So Law 360 identified it as a trend. And the case that gave rise to it, that we sort of highlighted as a starting point, was this case that happened in 2023, and it happened in New York. There was an individual named Jordan Neely, who was experiencing some mental health challenges, was also experiencing homelessness. And he had been killed by an individual named Daniel Penny on the New York City subway system. And the Manhattan DA's office had charged Penny, who was a Marine, I think he was 24, younger guy, with second-degree manslaughter after Neely had been killed on the subway. And your listeners might remember Neely had been a Michael Jackson impersonator. That was a lot of the photos that were sort of covered of him showed him doing that. Penny's defense was that he was acting in self-defense and that Neely was threatening passengers on the train. As the investigation went on by the Manhattan DA's office, they found out that Neely had this mental health crisis and had been, at the time that he had been killed, he was homeless. And Penny started a crowdfunding legal fee campaign, and the issue became very politicized. So there were politicians who were on the left who came out in support of Neely, and there were politicians on the right who came out in support of Penny and saying this was self-defense. And Penny had raised a really significant amount of legal fees. I think it was something like $1.5 million pretty quickly in his defense. And so the Law 360 reporter said, can you write about this? Can you do this? First of all, is this ethical? What are the issues that are associated with it? And so Julienne and I just dug into what do the rules say, what do the ethics opinions say, and then following this, we've actually had a number of clients who have reached out who have said, this is really interesting because this potentially opens up a new pathway for me to fund my defense or fund something on the plaintiff side. What are the pitfalls? How do we deal with it? So that's how it came to us.
Absolutely. And I'm curious, is this a new phenomenon in law where you have crowdfunding of these, public cases? Or is this something that there is some precedent for?
So there's definitely some precedent for it, but it's relatively new. It's sort of as new as crowdfunding, which I think maybe 10 years crowdfunding has been a thing. I'd be surprised to learn if it had been so much before that. The opinion that is the sort of precedential opinion is there's two. So in 2015, the Philadelphia issued a bar opinion addressing the situation. And then in 2018, DC did. And those ethics opinions always usually trail a couple of years after something has been around. So I'd say probably about 10 years this has been happening. But I think it's gotten a lot more interest as time has gone on and people have gotten more comfortable with the idea of crowdfunding, particularly with political campaigns, for example, or just anybody. I see now much more people posting stuff about crowdfunding. And so I think it's gone sort of hand in hand with those. And so there is precedent for it happening. But I think the scale on which it's happening is a lot larger, right? And it's happening and people are raising money a lot more quickly than they used to be.
I'm curious, when it comes to crowdfunding in criminal defense cases, what sort of cases are most likely to attract crowdfunding?
So I don't think either of us have done a survey of all the cases that have had crowdfunding, but my best guess and my sort of anecdotal thoughts on this are that ones that are politicized in nature. Because I think that when there's an issue that becomes political, you just garner a lot more attention. And I think this Penny case became political. I think it's on its face to me as a lawyer. It is not a political case. It's a manslaughter case. I don't see politics in that. It's just he was charged with manslaughter. But as we know, in 2024, a lot of things have become political and people have sort of taken sides on on issues. And this became a case where there was really a political divide in terms of who was sort of coming out in each camp. So I think that those types of cases tend to get more attention, but also defense cases where you have somebody who is a super sympathetic defendant, and so what makes somebody a sympathetic defendant? Well, I think that depends on who the audience is, who's listening to it, right? And who sees them. Some people are quite sympathetic to some and not sympathetic to others. But I think when people feel like they're giving money to a cause as opposed to giving money purely to a legal defense, I think that tends to feel different. And people tend to, you see more success with it, I think, because they feel like they're almost giving to a political cause as opposed to literally funding for lawyers to draft briefs and, interview witnesses and do some of the more mundane tasks that perhaps people are not, I want to give my $500 to that cause, for example.
I would add one more thing about this case. I think what made it interesting and what caused such a feverish following of this case was that it raises a lot of the issues that are much more in our collective consciousness nowadays, issues of race and class, and now a greater awareness of homelessness and the issues related to that, mental health. And so I think that this was a case in which there were a lot of comparisons that could be made. Someone who was well-to-do, someone who was in the armed forces, someone who was white versus someone who is experiencing a mental health crisis, someone who is homeless, someone who I believe was not white. And so I think that, like Hilary was saying, this was absolutely politicized. And I think the reason why it was because it was ripe with all of these issues that are so much more in our consciousness nowadays than they may have been in the past.
This episode is sponsored by AutoTrader. Credit scores, down payments, interest rates. Car buying can be a numbers game, but you don't have to be a math expert to get the keys to your dream car. Just use Kelley Blue Book My Wallet on AutoTrader. Crunch your numbers and get your personalized results so you know exactly how much you'll pay each month for your car. It's like having a magic wand for your wallet. Presto, the car you've been wanting is now within reach. So hit the road and leave your calculator at home. Find your next car on autotrader.com.
What makes a life a good one? Is it the adventure you have? Or the friends you find along the way? Maybe it's pursuing your passion while striving to protect, defend, and save what you believe in every single day. So what makes a life a good one? In the Coast Guard, we think it's all of the above and more. But you'll have to find out for yourself. Visit gocoastguard.com to learn more.
Across America, BP supports more than 300,000 jobs to keep our energy flowing. Jobs like expanding our biodiesel capacity in Washington state and reducing operational emissions in the Gulf of Mexico. It's and, not or. See what doing both means for energy nationwide at bp.com/investing in America.
Yeah, absolutely. From the article and from what you're saying, it really seems like that case in particular hit a lot of nerves on both sides, really. One thing I was curious about is just from the functionality of these crowd-funded campaigns. I'm curious, from your experience and your research, are these mostly for private criminal defense, or do public defenders do this too? Is it usually to get legal representation, or can it be something as hiring experts to come speak at a trial?
So it's really interesting because you were mentioning at the beginning about the case that had sort of this public defender bent to it. I've never heard of crowdfunding legal fees to be used by public defenders. I would imagine that there are real restrictions around doing that because public defenders are funded by government dollars, taxpayer dollars. I haven't looked into it, but I've never seen it happen before, and I've never heard of it happening before. I think in terms of what the money ultimately gets used for, I think that's one of what clients I have spoken to who have engaged in crowdfunding of legal fees find is one of the biggest benefits is that they can sort of use it for whatever they want to use it for if they've made the right disclosures. And so usually the money is not the way that the crowdfunding page is structured doesn't designate what you're giving money for. But that's one of the things that Julian and I touch on in the article, and it's really important to mention, is that anybody who is funding something, there are certain disclosures that are required, right? So if you want to give money to somebody's defense and you want that money earmarked for something, you need to be able to communicate that, and there needs to be the requisite disclosures about what's going to happen. Now, the reality is that, well, one, money is fungible, and two, that it's unlikely that whoever is setting up a crowdfunding page is actually going to want to do that, to say, oh, this $500 goes to like the witness section, and this $500 goes to doing voir dire to pick the jury. I've not seen it, and I think it would be sort of a nightmare to manage it. But that is one of the really important things. And so when you see like a well-structured, compliant crowdfunding page, what it essentially does is says you are giving money to fund this defense. As the lawyers, we are choosing how this money gets earmarked, and the client, in conjunction with the client, and by giving us this money, you are sort of acknowledging that that's how it works. Because the alternative, I think, ends up just being too difficult to administer properly.
Absolutely. Yeah. And I imagine, in a case, where there's criminal defense going on, you don't want to let the donors know about your strategy going in, or what witnesses you're thinking about calling, that, there'd be all those confidentiality issues.
Yeah, I think I would even go a step further and say it's not that you don't want to, it's that you can't, and that you would be violating your ethics obligation. So 1.6 is the rule that governs confidentiality between lawyers and clients. And I think one thing that tends to surprise non-lawyers in particular is that confidentiality is much broader than attorney-client privilege. And so attorney-client privilege is communications between a lawyer and his or her client in anticipation of litigation. It's actually pretty narrow, but confidentiality is incredibly broad. Every jurisdiction has a slightly different variation. But if you take DC's, for example, it says that any information that you learn from a client in the course of representation that the client has asked that you not repeat to anybody, or that could be viewed as detrimental, is confidential and cannot be released. And what counts as detrimental is incredibly broad. Even just the fact of litigation could be considered to be detrimental, like that you have been sued or that you wish to sue somebody else. And so one of the most important disclaimers that you need to have when you have a crowdfunded page is to say nothing that we by giving money to this campaign, you acknowledge that we are not going to tell you anything about this case. We're not going to give you any insider information. We're not going to take any of your feedback. You are simply donating money because you believe in that this case should be litigated in that we should have money for lawyers and for the ancillary costs, but we can't tell you anything at all, because if you do, then you as a lawyer run a risk of violating one of the rules of professional conduct and putting your law license on the line.
And I would also add that it's understandable that donors would expect that maybe the attorney, if the attorney is the person running the fundraiser as opposed to the client, that the attorney would provide updates or otherwise provide information about how the case is going. And one of the things that we discussed in the article is that you probably shouldn't do that. If you're going to do that, a lawyer absolutely needs to get the informed written consent of the client. And what that means is that they say to the client, look, you're the person who directs the representation. It's up to you. But if you want me to provide updates about this case, you have to tell me exactly what you'd like me to disclose and what you don't want me to disclose. And B, you have to be aware that this will, as Hilary was saying, waive attorney-client privilege, because it's no longer information that's being held within the confines of the attorney-client relationship. And so generally, our advice would be to not go down that road at all and to just not provide any information about the representation or what happens in the litigation.
In terms of the person setting up the fundraiser, the crowdfunding page, is because of some of those confidentiality concerns, is it best for the person running this to actually be one, or the attorney for the beneficiary, for the defendant? Or is that a little bit, there's more wiggle room for that?
I was going to say, from an ethical perspective, it's much, much more simple to just have the client administer their own fundraiser and then use those funds to pay the attorney. It becomes much more complicated and much more rife with ethics issues when you have the lawyer administering the fundraiser, but you can certainly do it as long as you're very aware of what the ethical limitations are. And if you do it, you have to have a written fee letter that outlines the fees that you'll be collecting. You have to have an engagement letter that outlines the scope of the representation. And in that letter, the client essentially would give permission to the attorney to accept those fees, because typically a lawyer cannot accept fees from anyone other than the client unless the client consents. So that would be one of the many issues that you would include in a very well fleshed out engagement letter, saying, look, I'm going to administer this fundraiser on your behalf. Unless you tell me otherwise, I'm not going to provide any information about the representation or about your case. And in doing so, you're authorizing me to accept the money that is collected for your legal fees and the expenses that I incur as your attorney. And one of the other key things that happens, which we may discuss a little bit later, is how the money is actually paid out. It's very important that the money is separated. So it's not as though the lawyer takes all of the money and puts that money right into their operating account as a profit. It doesn't work like that. So what has to happen is that the money is put in a trust account for the client. And as the attorney incurs expenses, either from the court or filing fees, or just works time that they then bill to the client, the lawyer still has to invoice the client, but then the lawyer can take the funds that are earned or incurred from the client's trust account and then put them into the operating account. So all of these things are typically things that you would have fleshed out in an engagement letter so that there is nothing left up to chance as far as making sure that the money is properly earned by the lawyer.
That makes a lot of sense. And before we talk about what happens with the money, I'm kind of just interested in more of the mechanics. In the Penny case, they used a fundraising source called Give, Send, Go. In the Richard Allen case, which is the case we focus a lot of time on, they're using a service called Pay It, and then the numeral 2. So an obvious question is, why are people using tiny sites like that, which most of us have never heard of, instead of the big sites like, say, GoFundMe?
I was just going to say, at kind of a baseline level, it seems like there's been kind of this proliferation of alternative services, kind of like how, now in addition to Airbnb, there's now Verbo and, couch surfing and whatever. And so there tend to be special interest services. So for example, GoFundMe, to my knowledge, is not religiously affiliated. It's not affiliated with any particular cause. Whereas the one used in the Penny case that you just mentioned, I believe that is a Christian fundraising platform. And then I believe that there are other ones that are similarly special interest or that have affiliations.
Absolutely. One question that I had is, like, looking at this broadly, what are some of the benefits of doing this? From a defendant's perspective, from a lawyer's perspective, what are some of the opportunities and benefits that can come with crowdfunding legal fees like this?
I think the biggest one is that you can do things you wouldn't otherwise be able to do, and it opens up all kinds of doors. I think one of the primary, so Julienne and I, in doing legal ethics and malpractice work, our clients are lawyers almost exclusively. And I think one of the biggest complaints that you hear from lawyers is that there is more they wish they could do, but the client won't pay for them to do it. So if you bill by the hour, for example, then every hour you spend is an hour that the client has to pay for. And so it would be great if we could take 3 more depositions. It would be great if I could write this additional motion in limine. It would be great if I could, and there's lots of other things that lawyers would want to do, but if the client won't pay for you to do it, then, at some point you decide what's worth it to do for free and what is work you're only going to do for a fee. And so I think it allows lawyers to have just greater resources to do more things in a defense case, if it's a defense case. And it opens it up to a whole host of people who otherwise wouldn't be aware of what the case is, right? So when you're crowdfunding legal fees and, the Penny case, like, these are all these people who have nothing to do with the case, who are just independently giving giving money and allowing there to be additional resources. So I think that's one of the huge benefits. And defendants legal fees are expensive, and you can be a criminal defendant from any walk of life, right? You can be a well-off criminal defendant who can pay legal fees easily, or you can be a criminal defendant who doesn't have enough money to pay for fees, which is why I think your question about public defenders is particularly interesting. I'd be curious to know the answer about it, but my instinct is it would be restricted. But those who are eligible to have a public defender and then choose to make use of a public defender, obviously, public defenders, as we all know, are very overworked and resource constrained. And so this sort of opens up the opportunity for those who don't have a public defender and have private representation for their representation to do more. And then I think there's another piece of it, which is engaging public opinion, which is a sort of dicey issue because the rule of professional conduct is Rule 3.6, and it governs trial publicity and says what lawyers can and cannot do in the course of representing a client. But the overarching idea and philosophy is that lawyers should not be in the business of politicizing and publicizing their cases. Now, if you look at stuff that's going on right now with Trump, there's a lot of that has happened in a sort of a way that maybe has not happened before. But the rules of professional conduct impose restrictions on lawyers about what they can say about ongoing cases, with the idea that they should not be prejudicing the jury, for example, right? You're not supposed to get on TV and say things that would impact what a jury's deliberation of your case. But one of the things that crowdfunding does is it sort of gets everybody to care about things. It gets a larger pool to care about things. So it's sort of maybe a way around some of those restrictions, because it's not the lawyer saying things that the lawyer's not allowed to say. But if you've sort of gotten the would-be jury pool to be aware of the facts and care about the outcome, then perhaps you've gained an advantage you otherwise wouldn't have had.
Well, you mentioned some of the potential benefits of crowdfunding criminal defense. Let's ask the obvious follow-up question. What are some of the potential pitfalls of crowdfunding criminal defense?
So I can start off with some, and Julienne chime in here, but I think some is that when people give money, often they feel entitled to certain things, right? So if you've given money and then the lawyers are tight-lipped about what's happening, there can be frustration. It's also, you now have to deal with how you administer this. And I'd say that the most common rule violation that results in a lawyer being suspended from the practice of law or being disbarred that I see, and so this is, my anecdotal take, is not properly dealing with client money. That is among the things that the bar cares about. I'd say that's pretty close to number one. And so now you have to deal with money in a way that you probably never had before. And so the way that it works, and Julienne had mentioned this at the outset, is that the money doesn't just become the lawyer's money, and it has to be put into a trust account. In DC, it's called an interest-bearing trust account. And you only get it when you earn it. But that raises questions of when have you earned it? And what fees are reasonable in that circumstance. So normally when you invoice a client, depending on how your arrangement works, the client sees in close to real time how much time you're spending on various tasks, and then you invoice that. Now, it's possible if there's this big pool of money and you're doing all kinds of different tasks, and then, calling on that money as you've earned it, that raises additional questions because it's not coming directly from the client anymore. And so is everything you're doing reasonable? And the reasonable check often happens practically because the client is paying your bills. But if now it's this pot of money that has been donated and you've had all these disclaimers that say once you just donate the money, you can't have any say over it, ensuring that what you're doing is consistent with the rules and consistent with 1.5, which is the rule that governs the reasonableness of fees, but also consistent with how you have to segregate client money and earn money, which is the 1.15 rule. And so I think one of the biggest drawback is perhaps just the technical aspects of doing it and managing it and making sure that you're compliant, because it's this novel way of dealing with fees. But I'm curious, Julienne, if you had anything you wanted to add to that.
Yeah. I'd like to touch on the behavioral aspects of it as well, and there's a couple different points here. The first is that the attorney can't charge a higher fee just because they have this big pot of money sitting around. So they can't say, hey, I usually charge $100 an hour. I'm going to now charge $200 because you have all of this money. That's number one. Number two is that now, because the client is not personally responsible for paying the invoice for the attorney's services, there tends to be a lot less oversight. And Hilary touched on this, that typically you can see in a lawyer's bill how long they spend on each task. They divide it out. And here it makes sense. If a client receives the invoice, but the client's not paying for it, they don't really care if the attorney is overbilling. So I think that becomes a slippery slope where attorneys can take liberties and charge more than is appropriate for certain tasks in order to spend down that money. And then one of the other issues you tend to have is when you end up with excessive funds from these fundraisers. And that's something that absolutely can happen. I think happens quite often when you have these very sensationalized cases that get a lot of media attention, like the Penny case, where you end up with millions and millions of dollars. And in some of these cases, they settle. And so the question becomes, what happens to those funds? And the answer is that the funds belong to the client. And so ultimately, unless the client directs the lawyer to do something else with them, like donate them to a charity, they have to go back to the client. But other than that, things should proceed exactly as they would if the client were paying. The lawyer should charge a reasonable fee based on the work that's done. The lawyer still should advise the client about what to do based on the amount of funds, or even if the client's willing to spend additional money outside of what was fundraised. And whatever money is left over goes back to the client.
I'd like to follow up on this to make sure I understand correctly. So hypothetically, if I donate money for the defense of, let's say, Charlie Manson, and not all of the funds are used for the defense of Charlie Manson then basically just gets to keep the overage?
Yes. Unless, of course, the client says, I want you to refund proportionally whatever the excess funds are to the donors, in which case, and Hilary, if you wouldn't mind chiming in here, at that point, it would be the client directing the lawyer to reimburse the funds. And I think at that point, with the client's direction, the lawyer could then theoretically pay out other parties, but you'd have to get informed written consent from the client to do so.
Yeah, that's right. And what you, I think, often see in these cases is, and what we advise clients to do is to say where the excess will go, so that all parties are informed. And so I just had a case recently where a client set up, I spoke to the client's lawyer, but the client ultimately set up a crowdfunding source, and we recommended the client say anything more than what is needed for my defense is going to be donated to this charity, so that you sort of avoid that problem. Because what you don't want, what the lawyer doesn't want, in our perspective, is we're coming at it from thinking about what the lawyer's liability is you don't want a bunch of money that was not given to you that you somehow have to figure out what to do with, which is why I think Julienne was being so clear about, this is really the client's money. And so that's why it's better if the client is the one who starts it and is the owner of the account, because figuring out what to do, and lawyers deal with this problem. They deal with a version of this problem all the time. If, for example, they get an advance on fees, and the case settles, or a client passes away, or they can't locate a party, there's a judgment, and they're supposed to give something to another party, and they can't locate him or her, and it just becomes a challenge to do. So that's one of the things to keep in mind.
That makes a lot of sense. I know I saw with one high profile case, the Karen Reed case, they noted at the bottom of their fundraiser that any excess fees will go to the Innocence Project, which seems smart because it's also kind of aligning with the cause of saying this is an innocent client.
Absolutely.
Kind of dovetails nicely, I think.
Definitely. And one thing that at least the DC bar has said unequivocally is that they really discourage lawyers from over collecting in fundraisers. They encourage lawyers to cut off the fundraiser once they believe that they've gotten sufficient funds. And they say outright that lawyers do risk putting themselves in a position where they may commit ethical violations if they just continue to fundraise needlessly. That's seen as an unethical practice. So there is very strong encouragement for lawyers to keep close tabs on how the fundraiser is progressing and to cut it off as soon as there's been enough raised. And one thing that I should have mentioned earlier, when you were asking me why a client would choose a particular crowdfunding platform over another, is when you're talking about these very highly politicized cases that implicate, very important issues, I think people also want to get visibility within those specific communities. So for example, in this particular case, they chose a Christian platform, but there was nothing inherently religious about this case. But there was some measure of evaluation between the client and the lawyers where they thought, okay, if we post it on a platform that has this particular leaning, we're likely going to get a larger contingency of donors than we would otherwise. And so I think that absolutely is the result of a conversation in which there is some, maybe even some artificial politicization of the issues in order to garner more funds than you would ordinarily.
Absolutely. One thing I was curious about, and you mentioned just now about like cutting it off at some point. And I guess in many traditional fundraisers, you do say, okay, we've almost met our goal of 10,000. Let's go for 20. That's pretty common within fundraising in general. Like if you're doing well, keep playing your, winning hand. But is that allowed? Is that okay within reason within some of these legal campaigns, or is that really more frowned upon, or is it a bit nuanced depending on the situation, I guess?
I guess it's very nuanced. There's no, at least from what I've seen, there's no particular number or percentage or cutoff above which you're going to find yourself facing ethical violations, or you're going to, find yourself in a situation with the bar. Yeah. So I think it's very nuanced.
And it's also just really hard to predict how much things are going to cost, right? Like there's huge variation about how expensive, we don't know if the client is going to take a plea deal. We don't know if the case is going to go through to a verdict and then be appealed. And so there's a big buffer, I would say, in terms of what counts as reasonable, but leaving it open in perpetuity and raising $20 million for the defense of a manslaughter case, not reasonable, right? But like, what's the difference? What is the line where 20 million becomes unreasonable? Is it, is 10 million, is 5 million, is 1 million? Penny raised 1.5 million. That I've seen defense cases that cost that, and that is an amount of money that could be reasonable to defend a case, depending on the complexity and how long the case goes on for. So very fact dependent. And the thing about, what the rules of professional conduct do, and when I was mentioning about us being sort of being a self-regulating profession, is there's a fair amount of discretion. And the standard is for most of the violations of the rules of professional conduct deal with a reasonable person standard, right? Some of them are more strict liability. If you, for example, commingle client money, in DC at least, there's not a mens rea, a state of mind defense. If you commingle client money, you are going to have a problem, most likely in DC. Other jurisdictions are a little bit more lenient about that, but lots of rules of professional conduct, a violation of them is, would a reasonable person under the circumstances have done X, Y, or Z? And that's a discretionary call in large part on the part of bar counsel, who decides whether or not to charge these violations. And then ultimately the tribunal hears them, which is usually a hearing committee. And then a hearing committee makes a recommendation. And then you have a board of professional responsibility that makes a recommendation. And then you have the court of appeals. So you've got lots of people in this chain all saying, was this a reasonable call for you to have made?
And one thing I was curious about, we talked a little bit about this so far, but just in terms of handling the money once it's been given from the donors to this platform, what are some other best practices and I guess means of doing this in order to ensure that a lawyer is handling some of these funds in a way that it does not breach any ethical guidelines?
So I'd say the biggest thing is what Julienne mentioned, which is you want to put everything into a trust account. And so all lawyers need to have an operating account, which is just your account as a lawyer. So it can be if you're at a big firm or if you're a solo practitioner, you need two accounts. You need one account that is, I've earned this money and these are my profits and I can spend them as I wish. And then there's the trust account, which for every client that you have, you need to have it needs to have its own separate space that is not accessible for the lawyer to spend until that money is earned. So step one for sort of dealing with this money is to put everything into a trust account until you've actually incurred legal fees. I think best practices include being very clear about what you're doing, how you're spending your time, how much certain things are costing, so that the client is aware of it as well. Because as Julienne mentioned, to get paid for legal fees by somebody other than the client, you need to get consent from the client. And part of the reason that the rules require that is that the rules contemplate a circumstance in which if somebody else other than the client is paying for the fees, that person will have an influence on the representation. And the course of the representation should only be governed by the client and his or her lawyer. So you want to make sure that it's clear to the client how money is being spent and what it's being spent on. And ultimately, the client gets to say, yes, this is reasonable, or no, I don't want to do it. And just the fact that you've gotten crowdfunded sources doesn't mean that the lawyer has carte blanche to make all the calls, right? It's still, because it's viewed, as Julienne mentioned, it's the client's money. It's just the client has gotten the money in an unusual way, but it's supposed to be viewed as the client's money. So the client can make the call that certain things are not where they want the funds to go. And we're sort of talking about this in the circumstance where there's excess, but lots of crowdfunding campaigns have, get a few $1,000s, right? And so you're not being able to do everything and you have to make calls, as you do in most cases, about what's worthwhile and what's not worthwhile. And so it's making sure that the client is the one that's making those decisions.
And I think to add to that, you bring up an important point, Hilary, which is that in most of these instances, you're not collecting enough money to cover all of the legal expenses. So in those cases, it's very, very important to make sure that you have an engagement letter that sets out all of the terms. So for example, what happens to the excess? What happens if there's not enough money in the crowd source? Does the client pay? Does someone else pay? If someone else pays, is the client providing informed consent for the lawyer to accept that person's money to pay the legal fees? And I would emphasize in general, just putting everything in writing. Even the draft language for the crowdfund. So for example, if the attorney is going to include just 3 or 4 sentences of this is the case for crowdfunding for legal fees and expenses, you want the client to approve that language. You want to include the hourly rate that you're going to be charging, or if it's a contingency fee, you want to outline what that will be. You want to outline the fact that the client will be receiving invoices that outline the charges, even though the money will be taken from the client trust account. You want to outline every single possible aspect of this arrangement and try to consider every possible thing that could possibly go wrong or be disputed later on.
That makes a lot of sense. Better to have some anxiety up front than to be dealing with something bad happening down the road.
Absolutely. Especially because you don't want to end up in a position where, let's say, you run out of money from the fundraiser, and then as a lawyer, you have an obligation to your client. You can't just say, well, I'm just going to, step out of your case now. You ran out of money. You have to anticipate the fact that someone's going to have to continue to pay, and you're going to have to continue to provide representation to the client. And so you want to figure out ahead of time who's going to be the responsible party at that point.
That makes sense. I'm curious. It sounds like you both in your practice and with your sort of public outreach are doing a great job of kind of guiding lawyers through, what can be a bit tricky, but certainly a promising avenue to go down. Is there any like wider movement that you see of some of this becoming even more codified or more rules being put in place in terms of just guiding folks so that they're not making ethical mistakes or violating ethical boundaries, but also getting the benefits of being able to have more freedom to put on the defense or whatever they want to do in terms of representing their clients?
I think that you very well might see other jurisdictions issuing their own bar opinions. As I mentioned, there's one in 2015, one in 2018. And so I think other jurisdictions might weigh in and say, here's a clear roadmap. But the rules, there's not a lot of, I think, ambiguity about what the rules say on these points. It's really just looking at the rules in this new context. But I think you could absolutely see bar associations saying, we're seeing this happen more, and we'd like, a single place where all of the rules implicated are talked about and are clarified so that people can do this in a way that is compliant and that they don't have to be worried, because there's lots of worthy causes that could really benefit from crowdfunding legal fees. And perhaps lawyers are hesitant to do it because they don't want to run into some kind of trap for the unwary.
I also wonder if in the future there are going to be specific platforms geared towards legal representation crowdfunding. That would make a lot of sense. And it seems like there may be a bit of a hole in the market for that particular service.
Yeah, I concur. I could see that being beneficial and being a space for not only individual cases, because I do understand why some people are uncomfortable when, it's a very politicized case and people are, throwing money at their favorite cause. But I could also see it being really good for like public defenders' offices to be like kind of getting a general funding, boost from that, because we know that can be underfunded in some cases, or, that could be helpful. So I could almost see it kind of functioning, a site like that functioning on a few different positive levels.
Yeah, absolutely.
I suppose this has been wonderful.
Thank you so much.
Yeah. Is there anything we didn't ask you about that you wanted to mention, or you think it's important for folks to understand this issue, or anything you just wanted to emphasize to sort of close out?
There's nothing I can think of. Julienne, anything that you think we didn't touch on?
Yeah, maybe the one thing that kind of underlies all of this is the idea that a lawyer has to be independent in their professional judgment, and that anything that happens over the course of fundraising for a client or collecting money that would threaten that independent judgment is something that just simply can't happen, at least under every single jurisdiction's rules and ethics opinions. And so, for example, if you have a situation where a lawyer becomes aware that a donor's interests are divulging from the client's interests, or you have a donor that's making things difficult or in some way impeding your ability to represent the client, that's a situation where the lawyer has to look within and evaluate whether they can continue to provide the representation and whether they're able to do so in an unconflicted way. And so in that situation, the decision may be to no longer use the crowdfunded money. In some situations, if it's incredibly severe, you may have a situation where the attorney even has to withdraw from the representation if there's a large enough conflict of interest. So essentially, just emphasizing the importance of independent professional judgment here.
Oh, wonderful. Well, Julienne and Hilary, you've both been wonderful guests. This has been incredibly insightful, and we just appreciate your expertise and you sharing your time with us.
Of course. Well, thank you so much for having us on.
Thank you so much to Hilary and Julienne. I think before we go into the specifics about the Richard Allen case, why don't we have some general thoughts about crowdfunding legal defense?
Yeah. So, I think we heard from our two excellent experts that as long as best practices are followed and an eye for confidentiality is maintained, crowdfunding defense can actually be a great tool in an attorney's arsenal. And I would say that being said, there seem to be some unusual facets about how crowdfunding is being deployed here in the Delphi case. It seems odd that another attorney who is not directly representing Richard Allen is being left in charge of these funds. And the status of Bradley, Rozzi, and Andrew Baldwin as public defenders in the case does raise some questions, because they're being funded by the state to do this. In addition to that, one thing that seems very clear from some of the documents is that it is not clear at this time what exactly the judge has rejected in terms of funding the experts.
More importantly, and we'll discuss this in a few minutes, it's not clear why she has rejected it. Is it for substance reasons or process reasons? We'll talk more about that later. I'm sorry to jump in there.
No, we'll jump in with that coming up. But for now, let's also talk about the overall landscape of crowdfunding defense. So I think probably the biggest crowdfunding website that people know about is, of course, GoFundMe. They do not allow criminal defense fundraising for violent crimes, except in the case of people who have been exonerated.
So in other words, if you've been accused of a crime and you've gone on trial and been found not guilty, GoFundMe doesn't have a problem with you fundraising to help pay for some of your legal expenses. But if you're currently accused of a violent crime, GoFundMe as a company has made the decision they do not want to be associated with raising funds for your criminal defense.
Yes, some very misleading statements have been put out there by people in connection with the Delphi case, noting that GoFundMe is used frequently for legal fees, but the stats they're citing have to do with civil legal fees, civil legal fundraising, not violent crimes. So this is a controversial issue. This is not something that is necessarily looked upon lightly by both companies and victims advocates and attorneys. It's a new thing, so I think people are kind of still in the process of figuring out what's appropriate, what's not appropriate. How do we do this in a way that is fair to defendants, but also, doesn't look terrible that you're raising funds for violent criminals. So one thing that we found was very interesting is where exactly Richard Allen's fundraiser is occurring. It is on a site called Pay It 2. That's numeral 2. And it's a small business based in Michigan owned by a parent company seemingly called Pay It Square. And we believe that it looks like the Delphi team gravitated to the site because they actually have a history of having somewhat contentious cases on there.
More specifically, they've hosted a fundraiser for Karen Reed, and put a pin in that because we will come back to that in a few minutes.
Yes. We reached out to Pay It to get a statement from them about, what's allowed. Does this coincide or does this align with their, values and policies? And they gave us a few statements in response to our questions. So we're going to just read that here. Quote, at Pay It 2, we uphold everyone's constitutional rights to a fair trial. Allowing the lawyers to provide the additional expert testimony for the defense prevents the defense from allowing a future mistrial, appeal, or allegation based on an error in proceedings. To be clear, identity verification and additional document retrieval is in progress to verify the experts and claims of the lawyer. Currently, the organizer is unable to receive payouts, so if there are any issues once documentation has been received, further action will be taken to refund the donations. Thank you for your understanding.
So that's a bunch of word salad.
Yeah.
And if I understood that correctly, he seems to be suggesting there that allowing fundraisers for criminal defendants is some sort of clever 3D chess to box defendants in so they wouldn't later have the option for an appeal. Is that the way you read it?
It's a bizarre statement. It strikes me as a very, very defensive statement, thinking that, they're going to be criticized for holding fundraisers for accused murderers. So they're trying to get ahead by that, saying, no, we're on your side. We're going to. I just think it's odd. I think if you're going to if you are going to have this be allowed, just have it be allowed. Being so defensive about it just strikes me as very strange. And I don't know why a random company in Michigan is concerned about, ensuring that there are no appeals. If there's going to need to be appeals, there's going to be appeals. I don't know. It's weird. And then
you wrote back.
Well, let me just say the stuff at the end there. I asked because at that point there had been some indication that David Hennessy, the author of the fundraiser, was not receiving funds. That seems to have been taken care of. But I was asking about why are they not getting funds from this? What's going on with that? So I wrote back with a few follow-up questions, and he responds, quote, at Pay It 2, we are in full support of the United States justice system and every citizen's constitutional rights. We do not have any opinions on the case, nor do we have access to the details of the case. Therefore, we will rely on our justice system to ensure that the correct person, parentheses S, are dealt with accordingly.
So that's it. They don't have access to the details of the case. And of course, anyone with internet access has access to the details of the case.
I thought Hilary and Julienne made a really good point where, like, I think we need, if we're going to do this, a site to arise that is legal focused in terms of crowdfunding, like that has the ability to kind of like think through some of these things. Because some of these responses just raise more questions. Frankly, they just seem very defensive, and I guess I would have expected like a tech company to just be more of like, well, it's not against our rules, so it's allowed. That would have been normal to me, I guess. But they're like trying to get ahead of something, I guess. So now I think we can jump into, now that we've covered sort of the platform for this crowdfunding, maybe we can go into some of the reasons that are been given behind the crowdfunding.
The defense had a filing on, I believe, the day of the hearing.
March 17th, yeah.
March 17th or March 18th, somewhere around there, where they discussed their complaints about expert funding. And even before we get into this, at the time the crowdfunder was initiated, at the time the crowdfunding campaign began, the judge had not ruled on this. So they were saying... They were basically saying we need funds because she's not giving us funds at a time when she hadn't even made a ruling.
So the crowdfunding was mostly a preemptive strike.
Yeah, that's a kind way of putting it. Why don't we start reading some excerpts from their filing where they're discussing the situation as they see it?
Yes, as they see it. And we should note that we're going to just kind of read through some of these. They're not all... next to each other within the filing. They're just...
But we'll jump in and try to interpret some of it.
Yeah, exactly.
Why don't you read the first excerpt?
Sure. So, quote, on February 24th, 2024, defense counsel filed a verified ex parte motion for a hearing on funding for experts. The 8-page motion contained requests for funding for the services of several experts and assistants counsel identified as necessary to prepare Allen's defense. In an order dated March 7, 2024, this court granted some of the funding requests, but denied others. The order is not noted on the CCS.
So right there's an indication that Judge Gull is not just unilaterally rejecting all funding requests for experts.
Yes, and it's not clear. We are hearing about experts and we're hearing about assistants. It's not clear what any, like, there's no further details about what any of this is. And so when I see people talking online about how she's rejected all their experts or won't give them any funding for anything, that's simply not true. That's a boiled down talking point that's being used to justify some of this, in my opinion.
Yes, and it doesn't reflect what the defense actually wrote in their filing.
In their own filing.
Why don't you read the next excerpt we wanted to discuss?
Quote, defense counsel requested funding for additional in-office assistant services. The state has enlisted help from at least 2 other prosecutors, as well as an untold number of law enforcement officers and their support staff, as well as the prosecutor's support staff. In February 2023, the Carroll County prosecutor obtained funding to hire a full-time investigator, a full-time secretary, and a special prosecutor, all for this case, and raises for himself, his current secretary, and his chief deputy prosecutor, given the additional hours they were working on this case. He told his county counsel that his office was drowning right now and needed some more people to work on this case. Recognizing the uniqueness of this case, Carroll County appropriated an additional $2.1 million in funding for Allen's case.
That's interesting. I think it's also worth noting that after this filing, the defense requested that an additional lawyer be added to their team.
Yes, Jennifer Auger. She's an attorney, and that was approved. So she will be able to that they will fund that. I believe the filing said that she can file invoices, and they will accept that. So
you just said something there that's going to be important later. Filing invoices. Well, I think it's important to note that, it again, whatever is being touted out there as some sort of unilateral black and white issue is actually more nuanced. Yeah, I want to read a quote from this filing and then talk about it. Quote, the court has denied all requests for anticipated expenses and costs that have not yet been incurred, end quote. So that really gets to the heart of this, It is not clear to me if Judge Gull has been denying expert requests because she doesn't believe those experts are needed, or if she has been denying those requests because they're not being filed in the appropriate procedural way. In other words, they seem to be asking for the right to have expenses approved in advance, while Judge Gull seems to want to require the use of invoices. I don't know about you, and I'm speaking to you, the listener, but I have had some unfortunate experiences in my life when I've been in car accidents. And when this has occurred, my insurance companies don't just say, oh, how much, Kevin, do you think you need to fix the car? And I then don't just pull a number out of the air and they give me a check. What happens is I go to a mechanic, maybe two mechanics, and the mechanics look at the car, figure out the damage to the car, figure out what needs to be done to fix it, how much it would cost to repair it, and then prepare a detailed invoice, which I then provide to my insurance company. And then the insurance company pays it. And it sounds like that seems to be something similar to what's happening here. Judge Gull wants a detailed invoice so she knows exactly what she's paying for before she cuts a check. And the defense attorneys seem to want instead just the right to say, well, we need $100,000 or $50,000 or whatever number they pull out of the air, and then have her just write the check and trust them that it would be used for appropriate services.
Yeah, and I feel like at this point in a case like this, where there's obviously been so much trust lost, that seems like a rather bold move on their part, frankly.
I don't even know if it's an issue of trust loss. It just seems that's the way.
If there's a process in place, then follow the process, frankly. And I don't know. It's possible that she preemptively excluded or said, I'm not going to fund some of these experts based on, I don't think that this is relevant, or this is, in which case some of their arguments about getting crowdfunding for experts might make sense. We don't have an ability to know that, though. If this is simply like, I'm not going to preemptively fund some private investigator that you want to bring in, then that's a completely different issue, because then they could feasibly get the funding. They just have to follow the process. And let me just also say this. I feel, again, like this is why when you have people who are frankly just spinning for one side, getting out and talking about this and essentially acting like it's an either or, it's a zero-sum game. They're not getting experts or they're getting experts. They're completely minimizing what the defense themselves are saying.
Yeah, I want to read another quote here. By refusing to pay the necessary expected expenses and by requiring invoices before paying for the limited services the court will potentially pay, this court has put the defense at an unfair disadvantage. So again, their complaint is, or it seems to be, she's not paying things in advance. She's not paying expected expenses in advance. She's requiring invoices. And so maybe it would have been more accurate if the fundraiser had been less about constitutional rights and more about the rights of lawyers not to pay invoices or prepare invoices.
Yeah, it's yeah. And can I just say, like, I think there might be, like we're heading towards a speedy trial in May. And so I feel like some of the tenor of their filing is like, well, we don't want to have to like just pay for it ourselves and then find out we're not going to get invoiced because we need this stuff quickly. But guess who asked for the speedy trial? Okay. If they're having to rush through anything at this point, then perhaps May's not realistic, and perhaps it was never realistic, and perhaps that's not in the best interest of their client if they're basically having to slap-a-dash things, right? I mean, like that is a deadline that they themselves are imposing at this time. And
exactly,
a lot of people have noted that it's very unrealistic, but at the same time, they did that to themselves. If this is all about basically like rushing through stuff and not wanting, I don't have time to file the invoices, just tell me I have the money. Well, again, that's on them.
Here's another quote from this document. The court stated that it would reimburse for criminal investigative services as long as a proper invoice was submitted. So again, I'm just wondering how much of this is just about invoices.
Yeah. I mean, we can't know because, as I said, it's possible that she substantively rejected some of their experts. We can't know that from these documents, but people who are assuming that that must be the case also don't know. We don't know. And frankly, there's an awful lot of invoicing in this document, and there's not a lot of talk about substantive rejection of experts unilaterally. Quote, the appointment of experts for indigent defendants is left to the trial court's discretion. The trial court is not required to approve payment for any expert that the defendant might find helpful. The defendant bears the burden of demonstrating the need for the appointment, with the central inquiry being whether the services are necessary to ensure an adequate defense.
So that acknowledges that Judge Gull has a discretion here.
She does have discretion. They can't just, I mean, again, I've used a silly example. There's no way they're doing this, but like if they said, we need to bring in a psychic who can tell us that Richard Allen wasn't at the bridge that day, she does not have to approve that. But, you know, one would think that any substantive, somebody who can speak to critical things like DNA or confessions would be approved of, potentially, as long as they had the bona fides. But we just don't know what is going on here. And I don't understand why people are just running with this narrative that it has to be that she's preemptively denying people because she's biased, as opposed to there's some sort of process issue that seems to be cropping up between these two groups.
So with that said, this crowdfunding effort was set up. The person placed in charge of it was David Hennessy, and that is surprising for numerous reasons. Number one is probably the fact that he technically represents attorneys Rozzi and Baldwin. He doesn't represent Richard Allen. So that makes him an odd choice. And another reason he is an odd choice, and I will phrase this as delicately as I can, it's an odd choice to put him in charge of something so important because his recent performance has not been what I would characterize as impressive. And certainly some of the early stages of this fundraiser also seem to be troubled. Like the address of his office that he provided in the fundraiser didn't match the Google address. The initial version of the text had some incorrect information about Richard Allen. And in fact, the text underwent several revisions. Doesn't exactly look good. And then we mentioned earlier that we'd come back to the Karen Reed matter. Do you want to explain that?
So Karen Reed is facing accusations of murder. This is a very contentious case. It's not one that we're particularly familiar with. So it's just we're bringing it up because it's also high profile, also contentious, also has a fundraiser on Pay It Too, which I should note appears to be run by one of her lawyers. So that already makes sense. But let's look at the text of the Karen Reed fundraiser. Quote, Karen has been wrongfully accused of John's murder, but is investing everything she has to fight for her freedom and for justice for John. Quote. Okay, so that's,
Why don't you read us from the original version of this Hennessy fundraiser?
Richard has been wrongfully accused of Abby and Libby's murders, but is investing everything he has to fight for his freedom and for justice for both victims of this heinous crime.
So basically,
they're plagiarizing Karen Reed.
They plagiarized the text of another fundraiser,
which is just okay. I mean, interesting. But let me just also note that investing everything he has public defenders. So I don't even know. Maybe emotionally, I don't know. It's just laziness. Frankly, it looks like laziness on the part of whoever set this up to be just basically cribbing language from another fundraiser that you're trying to emulate, obviously.
And they said, we need $25,000. They didn't explain what exactly that money was for or how that figure was arrived at. And then by an amazing coincidence, as soon as they get close to that number, they say, actually, we need $45,000.
Yeah, it doesn't seem like they came into this with any sort of specific. You would think that if Judge Gull was denying specific substantive witnesses or expert witnesses, that they would have some kind of ballpark of we would need $30K to cover that. But nope, they're just going to keep cranking it up. Yeah, it's interesting.
And I'm confused about how it works. Is David Hennessy going to get this money and then cut checks to Baldwin and Rozzi? or is he going to pay for these experts
from the fund directly? I don't understand this because his role in this has been to defend them from contempt charges. So it's not like this is a situation where you're like, okay, I can understand how this rolls into that, how defending them from contempt also rolls into being the manager of some financial enterprise here. I don't understand. I don't understand why he's in charge of this and not them. Also, I feel like, maybe he wants to help them out, but why not just set it up for them and put their names on it and put like a trust fund in that they have under it? I don't get it.
It was so poorly set up and organized that a number of people who were sincerely interested in donating were concerned that the whole thing might be a scam. And so because of that, David Hennessy actually had to go on YouTube and do an interview saying, no, it's not a scam. And that interview itself was, in my judgment, bizarre, because at one point in the interview, he starts alluding to state witnesses that are coming up in the case.
Yeah, he's noting that I'm not breaking any gag order because I'm not talking about any facts of the case, but here are the state witnesses who are going to come up.
He doesn't give their names, but he tells, what kind of experts they are. That certainly seems like a violation of the gag order.
Even if it isn't, it seems like it raises some questions.
In the same interview, he compares Judge Gold to Gollum. Is that how you pronounce it?
Yeah, Gollum, I guess, from The Lord of the Rings.
And I certainly understand that if you're in a bubble where you are surrounded by people who think exactly as you do, maybe things like that might play well. But I think to an outside audience, using that sort of othering language about the judge in the case doesn't play well. Certainly, we've criticized the judge for things that we don't agree with that she did, but that sort of language is strange, especially since this is a judge in a case he's currently involved with.
Yeah, it's bizarre. I don't understand it. It just seems like all in very poor taste and unprofessional from my perspective. Comparing the judge to some sort of like subhuman entity who's okay. I mean, I guess I'm like, what do you hope to gain from that? I guess except for pats on the back from people who are already acting crazy online. But why focus on that? Why play to that audience?
Yeah, I
I just don't even know.
I would think that if I were representing Richard Allen, I would be trying to find ways to bring new people to my cause, to convince people who may be on the fence to join my side and believe as I do. And when you go out and use that sort of language about a judge or things of that nature, you don't do that. You just look foolish to people who haven't already indicated they're completely in agreement with you.
Yeah, I think these people don't seem to understand that like a lot of people are actually turned off by kind of pointless bravado and insulting others. It just doesn't really seem professional. And I think then some of the points that you might be trying to make that might be good or might resonate with a wider audience get lost in the shuffle.
Shall we move on?
Yeah, absolutely. This is a part of the episode where we're going to actually talk about the video interview that Hennessy did, namely the platform it was on, because we think it's important to discuss this. This is a person who has taken on a very strange and frankly murky dual role in this whole case. And we think it speaks to how when you don't have boundaries in a true crime setting, you can get into some pretty ethically dubious territory pretty quickly. And at this point, we've been sort of watching this unfold from afar for some time. And at this point, we feel like it's probably necessary to say something about how uncomfortable it makes us.
Who are we talking about?
So we're talking about defense diaries, specifically Bob Motta. He's the person who interviewed Hennessy in this kind of bizarre conversation. And I would describe him as a pro-defense YouTuber.
Well, let me interrupt. I think it's important to be completely fair and accurate with what we say. I don't believe Bob Motta is a pro-defense YouTuber. I think Bob Motta is a defense YouTuber. I think he is not supporting the team. He's a member of the team.
that's certainly what he seems to want his audience to believe on some level. I mean, he's been pretty open about that.
He's made it clear he's not just promoting this fundraiser. He's had a role in its creation. He talks about how much he is helping the team.
The defense team. I remember at the Indiana Supreme Court hearing, he actually joined them. He got seats from the defense team that were provided to him. Kathy Allen. She was not there. Her Allen's mother was not there. Bob Motta got a seat. Again, I don't know if the other two weren't offered them. It just seems the optics on that are pretty weird.
He certainly has a very cozy, close relationship with these people, especially David Hennessy. You will recall that one of David Hennessy's filings, before it was made available to the public, David Hennessy gave Motta a sneak peek, and Motta rushed to YouTube with it. And I don't know if you would call that a leak or if you would call that a violation of the gag order since it was already filed. But at the very least, it shows the very tight and cozy relationship that he has with these people. And it was interesting to me that Hennessy shared this filing with him essentially about leaking right before a very contentious hearing about leaking. It was interesting judgment.
It really was. And I suppose for me, where Motta makes me uncomfortable in this whole situation is that I feel like there's an attempt to have it both ways. Now, for me, if you come to Indiana and you are so enchanted by this defense team that you want to provide your services toward them, whether or not that's compensated, who knows? Maybe you're just acting as a free consultant. But I think if you're going to do that, then you should proceed with extreme caution when covering it. Or maybe consider not covering it at all and instead focus all your energy on behind the scenes. Because when you're doing both, I'm going to talk about this, but it gets murky. Or you act independently and don't offer any sort of consultations or free advice or whatever this is to either side, and you act as an independent commentator. In that situation, you can be as pro-defense and biased as you want, and I don't necessarily think there's an ethical problem there because that's just your perspective. He's coming at this from a defense attorney's perspective, so I think if there was no sort of like weird working relationship behind the scenes, you couldn't really complain about that because that's just his perspective. To me, the melding of both is just, again, putting it kindly, ethically dubious. And let me give you an example of what I'm talking about and where I feel like there's a problem here. So I used to cover Walmart at my old job. I was the reporter, one of the reporters covering Walmart. So a blurring of the lines that I would see as similar would be as if I were going behind the scenes to Walmart's team as a reporter covering Walmart and starting to say, well, you guys, here's how you're going to frame your new self-checkout technology. And they're like going to me for advice. And I'm like reading their press releases and editing them and offering insights on what I think is going to really resonate with the media and get a lot of positive press on their new self-checkout technology. And I'm going around and taking calls with them and basically behaving in that way. And then I start reporting on the self-checkout technology myself and talking about how great it is and how like, wow, this kicks Target's butt and like, really leaves Kroger in the dust. And, kind of just going on television, writing articles in that vein. And honestly, if I got caught out doing that, I'd be fired because that's you're essentially acting as a unofficial spokesperson for something. And I think Motta is in an odd space because he's traditionally kind of portrayed himself as different things to different audiences. What he says in Discord is not the same thing as what he says in his Facebook groups, is not the same thing as what he says to your face. This has kind of been a common pattern with him, frankly, behind the scenes. But I don't feel he's fully disclosing the level of contact he has here and the level of closeness he has here to television audiences in particular when he does appearances. I think the level of contact he has, the level of closeness he has, he should be essentially claiming the role as of spokesperson and being honest about that so that people can assess what he's saying and saying, well, this could be his opinion or these could be talking points that he's been asked to put out there. And given, and I would probably feel pretty differently about this if this defense team hadn't tried to court the media or tried to attract media or tried to manipulate the media at every turn, but they have. So I don't, when they have, and when he has this level of relationship with him, I feel like I don't, what is he being told to say and what is he actually thinking?
Yes. It basically creates the appearance that he may not be an independent spokesperson. I don't believe he is.
No.
And more of a shill.
Yes.
To be blunt.
Yes.
It would be one thing if a veteran criminal defense attorney stands up and says, I think what Baldwin and Rozzi are doing is great. And maybe you as a listener and I as a listener would hear that and say, oh, this independent criminal defense attorney thinks this, and we'll give that a lot of credence.
Because that's their independent opinions. They're not friends with anyone. They're not running around behind the scenes with anybody.
But if someone who is affiliated with that criminal defense team stands up and says those things, I think we need to know that that's where it's coming from. And I think we would all give it less credence.
But
deservedly so.
But this is classic true crime because, I mean, this kind of line blurring occurs and it's not okay in my opinion. It's not ethically okay. And, you know, people just kind of accept it sometimes. And I don't understand that. You know, I'm not saying everyone has to be a journalist who takes a completely journalistic approach. As I've said, I don't have a problem with people being opinion-based or being analysis-based. That's fine. If you want to get out there and say that these guys are the best attorneys ever, more power to you. Maybe that argument should be made. Maybe people need to get that perspective. But when you're doing that and also bragging about how you're consulting with them behind the scenes and how they're like running documents by you, then I have a problem because then you're trying to have it both ways as some sort of independent analyst, and also as a guy who's joined the team as, you know, some sort of unspecified role, which just makes ultimately a lot of what you say look like shilling because it very well may be, and nobody has the ability to judge it.
And the reason we're talking about this now is Motta very, very actively promoted this crowdfunding effort. In a post on Twitter, he wrote, "This is not a fundraiser declaring that Richard Allen is innocent."
Yes, he couched it as some sort of lofty constitutional rights sort of thing.
But the original text of the fundraiser says, on October 31st, 2022, Richard Allen was arrested for a crime that he did not commit.
Oh.
That sure sounds to me like the fundraiser is declaring that he is innocent. But that is not even the fact that he is promoting the fundraiser, the fact that he was distorting what the fundraiser was about. That's not even personally my biggest concern about how he promoted this fundraiser.
Agreed.
He promoted this fundraiser in a tweet where he used a hashtag with the names of Abby and Libby. Justice for Abby and Libby. So in other words, this is a fundraiser for a man who has been criminally charged with the brutal murder of 2 young girls, and they are promoting it by using the names of those 2 young girls.
In a hashtag that has been appropriated from its original use, which was by families, the families of the victims and their supporters, traditionally, which was about finding who killed them. So it's being appropriated now for a different purpose.
We talked to several relatives of different murder victims to ask how they'd feel if someone used the names of their lost loved ones to promote a fundraiser for the person accused of those loved ones' murder. And I'm sure you won't be shocked to hear that their reaction was pretty negative.
They were appalled. One hypothetical that was brought up is, imagine in the 1960s or rather 1970s, and people who were supporters of Charles Manson were doing a, hashtag justice for Sharon Tate thing. I think that would go over pretty badly. To be clear, I'm not comparing Alan to Manson. Alan is not, he's innocent until proven guilty as far as I'm concerned. But I think that the optics of doing this are still equally horrible when you consider the perspective of the families, those who knew the girls, and anybody who doesn't believe that the case against Alan is weak.
I think these people just get into a bubble and they don't realize, or maybe they do and don't care.
I don't think they care.
I don't know. This sort of thing affects and hurts the families.
Real people.
Justice for Sharon Tate.
Yeah.
It's ridiculous.
It is ridiculous. And here's what bothers me. I believe that you should absolutely be able to advocate for anyone you think is wrongfully accused or wrongfully convicted. That is an important role of true crime. That's not something we should walk away from. But I believe, and I've seen people doing that advocacy work in very sensitive and thoughtful and compassionate ways. It means having a healthy separation. It means not doing theater when it comes to victim-centric approach. And what I mean by a theatrical version of victim-centric approach is like hashtag justice for Libby and Abby, as opposed to like actually thinking about like how this could affect their surviving family members and maybe considering having some space between the two and not appropriating something that you shouldn't appropriate in this case. I mean, just inappropriate.
Here's a thought. Maybe if you want to raise money for something, maybe don't use the names of murdered victims to raise those funds unless you have the permission and blessing of those who love those who were lost.
Yeah.
I cannot overstate how bad of taste this is in.
Yeah.
And I would never presume to speak for the Patty family or any of the families.
Or the Williams family.
The Williams family. But I did notice as we were getting ready to record, I saw that Kelsey German, the sister of Liberty German, retweeted something from Light the Way. And I want to read what she retweeted from them. So this is not her words. She's not breaking the gag order. She's just retweeting and amplifying something. Quote, in February 2017, the lives of Abigail Williams and Liberty German were taken. Since then, their loving families and friends have worked tirelessly to share their faces and memories on social media using the Justice for Abby and Libby hashtag. Recently, the hashtag has been filled with information about the man who is set to stand trial for their murder. Let's join together in support of Abby, Libby, and their loved ones as we share their pictures and stories as we take back the hashtag Justice for Abby and Libby. That's what that hashtag is about.
That is.
It's not about trying to make a buck for any reason whatsoever.
Yeah. And the fact that, again, you have a man who has declared that he is essentially working for the defense team, who's then hawking a fundraiser to raise money for said defense team, including a guy who's become his buddy, essentially, David Hennessy. And that he's not only doing all of that, which I frown upon, but then adding insult to injury by appropriating a hashtag and sort of a movement that has traditionally existed to support the victims' families and remember the victims themselves is something that I find pretty abhorrent. And I just feel like, sometimes we hold our tongues on stuff that's happening in this case and that's the appropriate approach. But in this case, we've gotten to a point with this behavior that I just don't feel comfortable staying silent on it because what's happening is unethical and wrong. And I feel like, when you're in our position, you're complacent if you're not saying anything about it.
I would say generally that Mr. Motta, has lowered the level of discourse around this case. He's actively lowered it. We've seen that firsthand, that he certainly amplified and spread false things about us, false things about the content of this show, false things about us personally. But he does this to others as well. He amplifies strange theories from strange people, frankly. And there was something I saw on Twitter the other day. Someone tweeted about this case. They got their man. In other words, they were saying this person personally believes Richard Allen is guilty. And part of Motta's response was, you quite literally would have been one of the people screaming to burn women at the stake, calling them witches back in Salem. Think about that, because it's the exact same mentality.
Can I just say no witches were burned in Salem? He's thinking about European witch trials. They were hung. One man was pressed to death. It's not just historically accurate. I'm sorry. I love early American history, so I had to say something. But yeah, so he's using the language of witch trials and accusing people who believe Richard Allen is guilty of, I mean, and to me, this woman's tweet was just, this is what I think, not saying like we should not have a trial or like, you know, any kind of extreme rhetoric like that I think a lot of us would find very objectionable, just sort of like, this is my opinion. But to me, when you have a man who is thrown in his lot with a group of people who are accusing uncharged men who have not been charged with a crime of doing occult rituals in the woods, and you're saying that the other side are the people who are acting like they're part of the Salem witch trials, the self-awareness seems to be very low there, because this is these are people who take defense rhetoric and take defense talking points, but at the end of the day, a lot of what they're doing is claiming that a group of people are child murderers based on what appears to be not a lot of evidence. So I don't understand where they can get off telling other people that they're behaving like they're in a witch trial when they seem to be using the same tactics, if not worse, against another group of individuals. I don't understand that. Do you know what I mean? Like I guess like I would love some consistency in the rhetoric. And to me, this would have not been so much of a problem if they were just taking a defensive stance on Richard Allen of like, the state hasn't proven their case and let's knock down the bullet and let's knock down the confessions. That would be one thing, but they've actively dragged other people into this to say that these are the child murderers. Look, they're doing weird religious rituals in the woods and they must have sacrificed 2 girls. I mean, where's the witch trial there?
I also wanted to highlight something else. Bob Motta makes a lot of mistakes about the facts in this case. I think a lot of people noticed after the last hearing, he made a mistake and said that Johnny Messer had kidnapped a young girl. In fact, it was something else entirely different. And
we had to correct that because essentially, like, the internet around this case, especially the pro-defense side of it, erupted and was carrying this as fact and spreading it around. It was misinformation. And what we said on the show was we felt it could be an honest mistake, which is, yeah.
Well, we'll get to that in a minute.
Yeah.
And more recently, there's been this issue of when these interviews were deleted in 2017, what did investigators think? Did they think that Holder was a suspect? And Motta tweeted out that, well, in 2017, Click certainly thought Holder was a suspect. And in fact, Click didn't even come onto the case until 2018. So what we're seeing here is he makes mistakes, and the mistakes seem to pretty consistently be mistakes that favor the defense.
Yes. Also, just a sort of an over-the-top aghastness about everything from like standard Indiana pretrial operating procedure that just is constantly framed by him in the most extreme, like, how could this be happening? And it's like, oh, and then you look into it and you're like, this always happens in Indiana or with this court, or this is not unusual. It's but like, again, people make mistakes, that's fine. But when all of your mistakes seem to favor one side over another, I think that's something to interrogate.
Now, the final thing I want to mention about all of this is if you follow Motta, you are surely aware that he often suggests that other people who cover the case are biased, that they are pro-prosecution. And I don't understand how anyone could possibly conclude that Bob Motta is a credible person to call out so-called bias. For instance, we really try to be even-handed and fair and to criticize either side when we think they deserve it. And with all that said, there are certainly people out there who do identify themselves as pro-prosecution. And of course, there's nothing wrong with that. but there is absolutely no equivalent of Bob Motta and his crew on the prosecution side. There are no pro-prosecution YouTubers who got special seats for court hearings from Nick McClelland. There are no pro-prosecution YouTubers who organize and promote fundraisers for the prosecution with hashtags calling for justice for Richard Allen. Motta stands alone in that.
Well said. Do you want to get to some other YouTube nonsense now?
You take it away.
Yeah. All right. So you've probably seen from the most recent prosecution filing that on March 28th, 2024, a YouTuber based in the Netherlands named Frank Wesseling posted a video with graphic crime scene pictures. These were the crime scene pictures from the defense leak. They got out to a number of YouTubers, as we've reported in the past, and one of those YouTubers was Frank Wesseling. So not only... Well, I mean, to go back to Motta for a second, he's one of those who's been kind of facetiously calling this leak a drip and oh, isn't it so crazy that they're making a big deal of it? Which that level of minimization, I think, is incredibly insulting to the families of the victims and also totally not necessary to defend Andrew Baldwin. I think the leak can be a big deal and Andrew Baldwin could be blameless in the affair. You don't need to minimize one to defend him. So it just seems like it's more of a cruelty thing at this point because, unfortunately, the worst outcome happened. As McClelland noted in his filing, these photos were sent by Wesseling to family members of the victims who saw them. So they've seen these. This is something that we were afraid was going to happen, that we were afraid that some creep was going to do this, and unfortunately, that has come to pass. So, I mean, I would hope that would make some of these people reconsider some of the rhetoric they use around it as an amusing little thing, and minimizing it because I think it's probably been devastating for those who love these girls who saw them like that. So Wesseling sent the crime scene pictures to family members and also posted this video. Then he himself took the video down, but obviously the damage was done. So Wesseling is a person with a history of very bizarre behavior in this case. And given that he'd done probably the most extreme thing one can do on YouTube, showing photos of dead children, we decided to reach out to YouTube for comment to ask if that was allowed or if that was within, was that a violation of its terms of service and whether Wesseling would be allowed to even continue on the platform given his behavior. And so we received the following statement from a YouTube spokesperson, quote, "The channel in question was terminated for violating our terms of service, which prohibit operating a YouTube channel following a previous termination." So then we saw that his channel was taken down. It turns out that Wesseling wasn't even allowed on YouTube in the first place because he's been terminated in the past. So in addition to that, posting such graphic crime scene photos was also an obvious violation of YouTube's rules. So he's gone. The way YouTube works is that when a creator's channel is terminated, they're banned from creating other channels because that would be basically trying to get around the policy enforcement. And in addition to that, they're not even allowed to be prominently featured on channels that are not their own. So they're basically done on YouTube after that. That doesn't mean that they can't come back and have some, get a new email, get a new IP address, put it on there briefly. But at this point, if you see Frank Wesseling on YouTube, you can report him and they will take him down because he's not supposed to be there. And I will say YouTube, we've been critical of social media around true crime in the past, but YouTube got back to us promptly. They acted professionally and they seem to care about not having stuff like this on their platform. So we were heartened to see that. And I think it's worth noting for other YouTubers who might be so inclined. I would believe that posting these photos at this point would probably engender and prompt similar treatment to that which Frank Wesseling received here. But I just think, again, I feel like this incident highlights the fact that we have had social media folks, people with small but wild platforms, essentially have a real impact on the people at the heart of this case. I've said sometimes I feel like it's the internet versus real life with Delphi. And when you have people on the internet doing really callous and upsetting things like this, it's not something that's happening in a vacuum. It's happening in a way that affects real people. And I think as a community, regardless of what our opinions are about the case, regardless of what our theories are, we need to try to, at the very least, stand up against things like this because it shouldn't be happening and it's unnecessary and it's just cruel. So that's what's happening on YouTube.
Thank you so much for listening. I hope you all have a wonderful weekend, and we'll talk again soon.
Thanks.
Thanks so much for listening to The Murder Sheet. If you have a tip concerning one of the cases we cover, please email us at murdersheet@gmail.com. If you have actionable information about an unsolved crime, please report it to the appropriate authorities.
If you're interested in joining our Patreon, that's available at www.patreon.com/murdersheet. If you want to tip us a bit of money for records requests, you can do so at www.buymeacoffee.com/murdersheet. We very much appreciate any support.
Special thanks to Kevin Tyler Greenlee, who composed the music for The Murder Sheet, and who you can find on the web at kevintg.com.
If you're looking to talk with other listeners about a case we've covered, you can join the Murder Sheet discussion group on Facebook. We mostly focus our time on research and reporting, so we're not on social media much. We do try to check our email account, but we ask for patience as we often receive a lot of messages. Thanks again for listening.
You've worked hard to build your brand, so why settle for one-size-all-fits branded clothing? Lands' End Outfitters creates apparel your employees will truly want to wear that unites your team in comfort and style. It's clothing that bolsters your brand identity and creates a unique connection between your brand, your employees, and your customers. It's why Lands' End Outfitters has been a supplier of branded apparel to some of the world's most respected brands for more than 30 years. From logo polos to fully customized branded wardrobes, our world-class outfitters will partner with you to help your team feel confident on the job and put your brand into action. From logo application to online ordering, Lands' End Outfitters offers seamless solutions that give you peace of mind, all backed by above and beyond expertise. See why Lands' End Outfitters should be your branded apparel partner. Go to business.landsend.com/pod20 and use code POD20 for 20% off your first product. That's business.landsend.com/pod20, code POD20 for 20% off your first product.